Yo, what is going on? I appreciate everybody for tuning in. This late night started a little bit later than usual. Why my chair feel funny? It feel like I'm taller than usual. Somebody probably jacked it up. Hey, shout out to Common Sense. Hey, first comment of the day. Big salute, big props. I'm a little disheveled. I can't even find my round of applause for the first comment of the day. Common Sense, a family member to the channel. Today we're gonna try to let me see. Where's the top chat done for you lately? Now that live all chat to get all the posts. It's all about Jackson. Right. Today we're gonna go in up. Hey, Juliet, what's going on? I appreciate you tuning in. Paul, what's good? So yeah, so we're gonna talk about this. My energy probably gonna be a little bit lower than usual because I had an event that I had to go to and I'm just getting back. So I'm kind of scrambling. But we're gonna talk about recalls. Again, I haven't been the most I haven't been on the what's going on in the village and the township as long as a lot of other YouTubers. But everything that I saw as it related to the recall effort and why it failed, uh, generally what I got is it was some procedural thing. It's a procedural reason why it failed, why things didn't work out, and I got interested. I was like, it was a procedural reason. So I was like, well, let me look up the cases, both of the cases. Well, one of the case, the 2022 case for the mayoral recall occurred in 2022. But while I was looking for that case, I found a 2016 case that related to a recall effort uh, and Tiffany Henyard as the plaintiff in her role as a trustee. So I thought that was interesting. And I was like, let me take a look to find out one, why was the recall effort unsuccessful? And it I don't think it was a procedural thing that wasn't followed. I think it was just a little bit of what I said all along. They kind of playing small town politics, and I don't think they had anyone to kind of look at how this should be done. But we're going to take a look at two cases today. The first one is a 2016 case because we got to get a little bit of a foundation. Because hey, we got to give I don't know. I got when there's an opportunity to give Tiffany Henyard credit, I have to give her some credit because she has some familiarization with the recall process and what would make a recall process unsuccessful or successful. She learned a little bit from the 2016 lawsuit, and I think her and her attorneys pivoted that perfectly into 2022 to make the recall effort unsuccessful. But we're going to dive into that and talk about it. As always, I'm Marcus. Here we do attorney reactions to news, current events, and everything else in between. And just trying to see what's going on with some of the crazy stuff that we see in the media outlets. Hey, I'm a licensed attorney, not in your jurisdiction. I'm a licensed attorney, probably not in y'all jurisdiction, but in many jurisdictions, but I'm not your legal counsel. So this is infotainment purposes. This is just me giving my opinion and takes and my perspective on topics. As always, find a professional in your area. And shout out to all the subscribers, over 17,000 subscribers, everybody, all the family who's in the comments. And shout out to the members of the channel. A big salute to you all, to all the members. You know what? Let me actually give the members a round of applause as well. Everybody, I'm appreciative, but a big appreciation and shout out to the members. You all are the official co-counsels, official executive producers, and you all have the access. So if there's something specifically you want to rap about, anybody in general, but hey, the members get a little extra love. Y'all shoot me an email, don't hit me up on TikTok because I'm probably not gonna check it. But IG, I check that one sometimes, and we'll see what we can do if it's the right content to get on and talk about. So let's go ahead, dive in, because let me see. Let me hit some of the comments up real quick. Let's see. Hey, I appreciate that common sense. Thank you, as always. Thanks to everybody in the chat. Can we please acknowledge how middle aged those of us are who are watching this as our Friday night activities? Yo, low key, I went to an event tonight and it started at 4, and I got home at about like 9 o'clock, and I was like, man, like I was really thinking about not getting on here because they threw my schedule off. I was like, man, they threw my schedule off. I had some more things that I wanted to do because I'm not even gonna pull it up, but I actually was gonna brief this case. I got parties, procedural posture, issue, rules, analysis. I was gonna do it like some real law school shit, but I had an event that I forgot about that I had to go to, and it kind of threw me off. But let's go ahead, dive into this first case. Y'all know I always like to put it like this, just in case y'all want to tune in and shout out and watch. And hey, real quick, let's address this comment real quick before we. Hey, shout out to everybody who is all the middle-aged folks out there, all the people who are mature intellectuals. Hey, there's a lot of things that you could be doing. So I'm grateful for y'all sharing y'all Friday night with me. And salute to being middle aged, to being older and mature, having a little bit of peace of mind. I just told somebody today, I said, man, I can tell I'm getting older because if I want to have a drink, I actually prefer to have a drink at home as opposed to like going out somewhere and having a drink. I would rather drink and sit in the comfort of my own home. But anyway, let's go ahead and dive into this first case, this 2016 case. All right. I'm going to go through the case and actually just kind of break things down and explain it as I'm going through because of the way I got it set up. Hold on, maybe I can move this over here. Let's see if I can move this over here. I'm not really a fan of that view. Let's move this back. I'm trying to see a good way I could set it up. Give me 1 second. I got to do a little struggle streaming. I'm trying to see a good way that I can set this up. You know what? That's not going to work. I'm gonna just have to. All right, I know what I do. I move this over here temporarily. Then I can keep an eye on the comments and all the good stuff. All right, we're starting with this 2016 case. This is the prerequisite to the 2022 recall. This occurred in 2016. All right. The plaintiffs in this case are Tiffany Henyard, Stanley Brown, and Robert G. Hunter Jr. They're the plaintiffs versus the village of Dalton. And Mary Kay Dugan, in her official capacity, is village clerk. All right. So this case is interesting. Let's go ahead and go through it. And it's actually not that long. All right. On June 1st, 2015, the village of Dalton, by a majority vote of its board of trustees, passed an ordinance providing for the recall of elected officials. Plaintiffs Tiffany Henyard, Stanley Brown, and Robert Hunt Jr. are duly elected village trustees who voted against the ordinance. Defendant appellant Riley H. Rogers, the village mayor, approved the ordinance, which was attested to by defendant Mary Kay Dugan, the village clerk. On September 24th, 2015, the plaintiffs commenced this action seeking a declaration that the ordinance was unconstitutional on a number of grounds. So Tiffany Henyard saying like, yo, this ordinance is unconstitutional. This recall is not legit. Remember what we doing here because we're gonna have to pivot to her mayoral recall. She clearly learned a little something from this experience. All right. It says, okay, the plaintiff commenced this action seeking a declaration that the ordinance was unconstitutional on a number of grounds, including that one, as a home rule unit, the village was required to submit the issue to a voter referendum prior to enactment of the ordinance. So the first point that she's saying was bogus is as a whole rule municipality, the village was required to submit the issue to a voter referendum before they enacted the ordinance. The trial court disagreed with Tiffany Henyard and Stanley Brown and granted the defendants, the village, their motion for judgments on the pleading and denied the plaintiff's motion for summary judgment. Now, this Illinois appellate court reversed that decision. So a recall was done. Tiffany Henyard, Stanley Brown, and another individual filed a lawsuit saying that the recall was bogus. The reason that they asserting the recall was bogus is because, hey, Dalton is a home rule municipality. The village was required to put the issue to a voter referendum before they enacted the ordinance. When they first went to court at the trial level, the trial court disagreed with Tiffany Henyard, and the village actually won. They filed a notice of appeal. Now they're in appellate court, and the appellate court is saying, whoa, 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 pump your brake. We think that this is a different result. Therefore, we are reversing the decision of the trial court. So they're overturning the decision of the trial court. At the trial level, Tiffany Henyard and Stanley Brown lost. They said that the recall was legit. They appealed it. Appellate court said, yo, they're right. This recall was bogus. Let's talk about it. All right, background. Oh, let me take a little pivot over here. All right, so background. In April 2013, voters elected Henyard, Brown, and Hunt to the office of trustee of the village for a 4-year term. Plaintiff's term expired in May 2017. Roger serves as Dalton mayor, and Dugan serves as Dalton clerk. Roger and Dugan's elected 4-year terms expire in 2017. Dalton is a home rule unit of government. Article 7 of the 1970s Illinois Constitution addresses the power of both home rule and non-home rule units of local government. Article 7, blah, 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 Section 6 pertains to the power of home rule units, while Section 7 applies to municipalities that are not home rule units. I don't even know why they put that in here, but Dalton is a home rule municipality. But they're just talking about this article explains what we have to do for home rule. This article explains what the process is for non-home rule. But Dalton is a home rule municipality. With respect to home rule units, Section 6 of Article 7 provides, except is limited by this section, a home rule unit may exercise any power and perform any function pertaining to its government affairs. Home rule jurisdiction can do what it needs to do to govern it because it's its own municipality, it's its own entity. Common sense. They make everything so verbose. Among the limitations on home rule powers contained in Section 6, which provides a home rule municipality, which is Dalton, shall have the power to provide for its officers their manner of selection and terms of office only as approved by referendum or as otherwise authorized by law. So we can clearly see just by that citation right there, the rule is right in front of us. A home rule municipality, Dalton, shall have the power to provide for its officers their manner of selection and term of office only as approved by a referendum or as otherwise authorized by law. So there has to be a referendum or some other authorization, maybe a constitutional provision, a state statute, but there has to be a referendum or some other provision to allow the home rule states to do their business. All right. In contrast to the board powers vested in the home rule unit, blah, blah, blah. Let's see. Home rule unit make clear that the powers of such local governments are limited unless otherwise authorized by law or specifically granted by the Constitution. That's what we just talked about. One of the constitutional grants of power to a non-home rule unit is to provide a referendum for their officers' manner of selection and terms of office. So you see early on they having this debate, and I'm gonna be honest, I don't know. We may dive into it. I've kind of skimmed through this earlier provision, but I'm kind of it's like I guess there's some either distinction that they want to make the difference between a home rule and a non-home rule, or they were trying to do some analogy of they both do something the same. I'm not sure as to why they're talking about non-home rule, but we're gonna go ahead and get into it. All right, so let's get down. On June 1st, 2015, by a vote of 4-3, the village adopted Ordinance 15-022, which adds a new chapters to the village code and provides for the recall of elected officials. As noted, plaintiffs Tiffany Henyard and her crew, Stanley Brown, voted against the ordinance. It is undisputed that the village passed the ordinance without approval by referendum. Honestly, we don't even got to read no farther. Like we don't even have to read no farther. But I'm gonna just scroll up. It said it is undisputed. So everybody agreed that the village passed the ordinance without approval by referendum. And we were when we were up here and we talked about, remember, Dalton is a home rule municipality. It says right here, Section 6, subsection F, provides a home rule municipality shall have the power to provide for its officers their manner of selection and terms of office only as approved by referendum or as otherwise authorized by law. Authorized by law means constitution or statute. So if there's no constitutional provision or no law that says the municipality can do this, this rule right here says they only can do their business with regard to anything associated with the term of an elected official by referendum. And literally, the next paragraph says it's undisputed that the village passed the ordinance without approval by a referendum. So, literally, reading this for 3 minutes, we get the gist of why the appellate court overturned the recall back in 2016. So let me go through it. I'm going to skim through it to see if there's any pertinent thing that we need to break out, because I really want to focus on 2022. But I wanted to talk about this because it provides some background and it puts things into perspective, because we know now Tiffany Henyard has some familiarity with what the home rule process is for doing a recall and how to comply with it or not comply. All right, let's see. The ordinance includes the following sections. So this is the ordinance that they passed without a referendum. Section 1-14-4, recall of elected officials. I don't understand how they did this in 2016 and then fucked it up again in 2022. That's kind of wild. I don't know. That's kind of wild considering they had this opinion to actually look at to figure out, hey, I think we know how we could do this correctly. And they cite all of the pertinent cases, but I don't know. That's just kind of some wild lawyer work in 2022. All right, not the referendum, the ordinance that did not have a referendum, which it needed by law because Dalton is a home rule municipality. It said elected officials hold office subject to the right of recall vested by this chapter and the electors of the village of Dalton. Subject to the terms and provision of this chapter, any elected official may be recalled and removed from office by a majority vote of the electorate at a recall referendum initiated as provided in this chapter. B, no elected official shall be subject to a recall at an election to be held during the elected official's first year in office or at an election held during the official's last 8 months in office. So that's interesting because as they wrote this ordinance, they didn't include the referendum, which they needed by law. But they also have language in there that provides a buffer. No elected official is subject to recall during the elected official's first year in office, and you can't be subject to a recall within your last 8 months of office. So that's actually interesting. Now, the next section lays out the recall procedure. Okay, I'm gonna go through that because that's not that long. Then I'm gonna skim through to see if there's anything viable. I'll probably skip down to the analysis because that's where the meat and potatoes are. Then we're going to jump into 2022 to talk about why the recall effort in 2022 was jacked up. All right, recall procedure, section 1-14-5. A proposition to recall an elected official shall be certified by the village clerk to the proper election authority, who shall then submit the proposition at an election in accordance with the general election law. If a petition requesting such action is signed by the electors of the village, numbering not less than 25% of the total vote cast in the last election for mayor of the village, and the petition is filed with the village clerk. They wrote this absolutely terrible. I see why they lost, because they wrote it trying to sound I guess provide a lot of legalese, but they could have wrote it a lot of way simpler. They could have wrote it much more simple and actually followed the statute and put a referendum in. And the referendum probably should be separate from the actual recall effort. I wouldn't put those two in the same provision. I think that's just a bad look. The proposition shall be in substantially the following form. Should named elected official be recalled and removed from the office, blah, blah, blah. blah 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 blah. Nothing. I don't see anything pertinent, so I'm skipping. The ordinance became effective upon. Okay, this ordinance became effective upon its passage and applied retroactively to individuals elected to village office in April of 2013 and thereafter. The ordinance provides for the recall of Dalton's elected officials, including the mayor, clerk, and trustees. The manner provided by law for filling of a vacancy relating to occurrences such as an elected official's resignation, death, disability, removal from office, a conviction of a disqualifying crime is for the mayor to appoint an individual with the approval of the trustees. All right. So, long story short, let's skip down to the analysis. So, if you're just tuning in, this is where we are. In 2016, the village trustees essentially passed an ordinance allowing for the recall of elected officials. They were supposed to have a referendum. A referendum is just a written provision that articulates what is going to be done. They were supposed to have a referendum because, according to the law, what we see in this case, a home rule municipality, which Dalton is, they need to have a referendum. And if they don't have a referendum, they have to have a constitutional provision. I haven't seen anything in here about the Constitution, and everybody agree. Henyard and Stanley Brown, the trustees, all agree that there was no referendum done, so they're already screwed. Now the analysis. Let's see how. I want to see how long this is. Okay. Do I want to get into that? Or let me see. Let me see. Let me take a quick. Mm, 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 mm. Okay, okay. Nah, we actually could pivot from this one. I think that's all the meat and potatoes. I think that's all the meat and potatoes that we needed from this one. So let's go ahead and I'm gonna close this out. Let's see. Let's close this out and let's bring up the 2022 recall. We're gonna bring up the 2022 recall. But before we do that, because I want to, because this one is these complaints is kind of a pain in the ass. So sometimes you got to jump in. But I wanted to go over here, jump on some of the comments real quick. Hey, we here, we diving, we doing kind of a deep dive into some legal nuances, but we're gonna get to the meat and potatoes of why the recall effort against Tiffany Henyard failed in 2022. We already see in 2016, Tiffany Henyard has some experience in court with kind of understanding what needs to be done in order for a recall effort to be consistent because a recall was done, an ordinance was passed, there was no referendum. The plaintiff, Tiffany Henyard and Stanley Brown, filed the lawsuit. The trial court said the recall was legit. This is back when they were trustees in 2017. They appealed it, and the Illinois Court of Appeal said, whoa, 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 pump your brakes. The trial court was wrong. Tiffany Henyard and Stanley Brown are correct, and the recall effort failed, and this is the trustee recall. So everybody know where we at. Let's see. Let's go and tap in. I appreciate everybody who tuning in. Hey, I appreciate that. Shout out to you, and yeah, because it's hey, shout out to you for hey, you like a little courtesy and respect for everybody involved in in this content creation thing and anybody involved in this chat. So shout out to you all. I appreciate that comment. Yeah. Let's see. Let's see. You want the feds to indict her already? This is the month. I think this is the month. I said sometime between Thanksgiving and Christmas. If I had to, I'm gonna say Thanksgiving and Christmas. If she get past Christmas, they might just go ahead and wait till after the election because it's gonna be interesting. But if I had to bet, I say that 31 days between November 24th and December 25th. Proof no one paid attention to their own ordinance and challenges faced in their own. Hey, I agree with that comment 100%. It seemed like they were always doing things a little shooting from the hip. just to see if things stick. And the worst part is all of this litigation related to minor mistakes that was made, the taxpayers are paying for it. That's the worst part. Oh, I appreciate that, Donna. Thanks for that comment. I appreciate it. Shout out to you for tuning in as well. But I definitely appreciate it. Let's see. I want us to get through some of these comments before we dive in. Oh yeah, they only indict if they win. Yeah. So let's. All right. So a Christmas present, Tiffany Henyard indictment, is that a gift? All right. So let's go ahead and look at this 2022 recall case. Let me see. So does the village get their money back from the attorney's mouth? Nah, they not getting no because it ain't no. Um, uh, I'm. I mean, luckily, I've never had to utilize malpractice insurance, but the village wouldn't get any money back unless there's a finding that an attorney actually engaged in malpractice. You can be a bad attorney. You could be a you can be a bad attorney and absolutely suck ass, but it's not necessarily malpractice. Malpractice is one of those weird things where like you have to be to be found like okay that an attorney actually engaged in now malpractice is a much worse standard than just like being bad. You can be like a D plus attorney, which isn't a great attorney. You can be a D plus attorney and not necessarily engage in malpractice. So, but that was a good question. All right, let's go ahead take a look at this. Let me see if I can pull this up. All right, so this is where the meat and potatoes are right now. 2022 recall effort. Everybody's tired of Tiffany Henyard and her games, her misappropriation of funds, her failure for what appears to do what's in the best interest of the village. So they trying to get her up out of here. All right. This is actually a good paragraph. I had this actually in my. Actually, let me read what I got because this is actually a little bit of a good overview. All right. So the plaintiffs is Tiffany Henyard in her official capacity versus the Village of Dalton municipal officers as defendants. All right. The procedural posture, essentially, procedural posture is how did we get here today? Where did the court? Somebody filed the lawsuit, then it went to court, then somebody lost, and they appealed it. So the procedural posture is just procedurally, how do we get to where we are today in the Court of Appeals? So the procedural posture, and I'm just reading off my own notes. A village board adopted a resolution placing a referenda on the ballot to establish a recall procedure. All right, now this is the first thing we got to look at. It looked like they tried to do the right thing because remember in 2016 with the recall effort, there was no referenda placed on the ballot, and we saw that as a home rule municipality, you need to place a referenda on the ballot. So immediately, just looking at the procedural aspect, a village board adopted a resolution placing a referenda on the ballot to establish a recall procedure and to recall the incumbent mayor. Remember, I said we know that you need a referenda, but one of the things I also said is I probably wouldn't put them on the same instrument. I don't know, probably because it's just too confusing. But they placed the referenda on the ballot, so they learned from 2016. And on that same ballot was the attempt to recall the incumbent mayor. On the eve of the election, the circuit court, the trial court held that the referenda were invalid. So the first time in 2016, they didn't even put a damn referenda up. Now they put one up, but the trial court said it was invalid. The circuit court's order was stayed, so they just stayed. They just put it on the table and left it there. It was stayed, and the election proceeded. And the village's voters approved both the referenda. They approved the referenda that needed to be on the measure, and they approved the recall of the mayor. This court, the Court of Appeals, stayed the certification of the results. So they said, hey, okay, everybody voted to get her up out of here, but we're going to stay those results until we can review the complex issue presented. Upon review, the appellate court affirmed the circuit court's judgment, so they agreed with the circuit court and concluded that both the referenda were improperly drafted. So the referenda was wrong, the recall language was wrong, and therefore ineffective. We entered a permanent injunction against the certification of the referenda of results. So they put a stop to them punting Tiffany Henyard out. So the issue is issue statement. This is real old school law. This is real law school stuff here. The issue is whether and how Illinois voters can recall their elected municipal officials, and were the referenda as drafted sufficient to effectively remove the mayor. One, there's a whole bunch of legal rules. One you're going to hear talk about is latches, and like people are like, "What is latches? What the hell is that?" Essentially, latches is where a defendant argues that the plaintiff uh, the plaintiff should be dismissed because the plaintiff delayed in asserting their right. The plaintiff had the right to raise a cause of action or claim, and because they didn't, the defendant is saying, "Hey, because they failed to raise that in a timely manner, it should be null and void because it's prejudicial to us. If y'all allow them to raise anything at any point in time, how can we adequately prepare defense?" So that's what latches is. When you hear it, you'll go through it. Now, all right, so let's get a little bit into the background. Your boy got some tea. All right, let's go ahead and get into the background. All right, plaintiff Tiffany Henyard was elected as a village president of the village of Dalton in 2021, a consolidated election. The six defendants, Kiana Belcher, Jason House, Brittany Norwood, Ed Steve, Tammy Brown, and Andrew Holmes, interesting, village trustees, currently comprise the village board of trustees. At a special meeting on December 8th, 2021, the village board placed two referenda at issue herein on the June 28th, 2022 general primary election ballot. So they put referenda number one is the referenda that outlines we're going to initiate a recall, maybe some language with how we're going to do it, how the process works. Referenda number two is the actual language to recall the mayor. So those are what we're referring to when we say referenda number one is the general referenda that talks about the process. Referenda number two is the actual language that talks about, are you voting to recall and get her up out of here? All right. The record does not contain copies of a signed or numbered resolution placing the referenda on the ballot, only unsigned ones, but the parties do not dispute their content. The first referenda question read as follows. So this is the first referenda, and I skipped through this case, but I'm just looking at it is already too long. If I see some shit like this on the ballot, I probably have to read this 2 times to maybe more if it's poorly written to understand what the hell they are trying to say. So I already know if I had to look at it 2 or 3 times and I still wasn't sure what the hell they were trying to say, no lay person who job it's not most people's job to sit around and read shit like it is mine and figure out what people are trying to say, what their intent was. So it's just too long. If I saw this on the ballot, I'd be like, what the fuck is this? All right. So the first referenda one, read as follows. This was actually on the ballot. Shall the following recall mechanism be adopted and effective immediately upon certification by the clerk, a county clerk for the village of Dalton? Not bad language. Recall of the village president mayor. Recall of the village president mayor of the village of Dalton is established, applicable to and effective. Now they fucking up. Applicable to and effective as of the certification of the results of the June 28th, 2022 general primary election. Recall shall mean the power of the electorate of the village of Dalton to remove the village president, the mayor, from office and to immediately create a vacancy in the office of the village of president, mayor, to be filled in the matter provided by law fulfilling such a vacancy. Which is by a majority vote of those voting. Look at this. Listen to how dumb this is. I know what they're saying, but it sounds dumb. I'm gonna read this again. All right, let me go back up. All right, it says recall shall mean the power of the electorate of the village of Dalton, the citizens, the people, to remove the village president, mayor from office and to immediately create a vacancy in the office of the village president, mayor, to be filled in a manner provided by law, fulfilling such vacancy by the majority vote of those voting on a question of whether to recall and remove the village president, mayor of the village of Dalton at a regularly scheduled election. That's written absolutely terrible. I think I know what they're trying to say, but it's written really bad. Then they say anytime you see said in something written to the general public is a terrible thing. Said question of whether to, you could tell attorneys wrote this and they did a bad job. Said question of whether to recall and remove the village president, mayor of the village of Dalton, may be submitted either by resolution of the Dalton corporate authorities or by petition in the manner prescribed by law for the submission of public question. That's actually crazy as hell. The way that is written, it's just fucking confusing. I actually had to read it a few times. Y'all let me know in the comments if y'all read that and did it just jump out and make like perfect sense to you. But just on me, just looking at it, I was like, well, what the fuck is this? I was like, this is just fucking confusing to me. All right, let's go ahead and jump back into the document real quick. Let me pull this document back up. I got so many documents on my screen. So that was referendum number 1. And the court is saying, like, yo, that referendum, as it was written, was fucked up. All right. The second referendum question read, now this is referendum regarding to the actual vote. The first referendum is to talk about the process. The second one is to talk about, okay, we're voting. Do you vote yes or no to get her up out of here? And they put both of these on the same ballot. So just think about how confusing that would look. All right, the second referendum question read, if the recall mechanism is passed by the majority of voters at the June 28th, 2022. Oh man, I already see the problem with this. Okay, I already see the problem with this. I'm gonna read this and then I want y'all, we're gonna talk about it because I'm sure co-counsel, y'all see this as well. The second referendum question read, if the recall mechanism passed by a majority of voters at the June 28th, 2022 general primary election, shall Tiffany A. Henyard be recalled and removed from office of village president, mayor of the village of Dalton, effective upon certification of the election results by the Cook County clerk. Now, I already see the problem with this because I'm confused now that I'm looking at it. The first one, I'm not even going to go back and look at it because it gave me a headache. But the first referendum described the process for recall. The second one is saying this is the actual vote on the recall. And as soon as I read this, I got confused. It said if the recall mechanism is passed by a majority of voters at the June 28th, 2022 general primary election, Tiffany Henyard shall be recalled and removed out of office for her position as mayor of the village of Dalton. The immediate problem I see with this, if I voted yes, I'm not sure what I'm voting for. And what I mean by that, maybe it's just me. I'm not the sharpest knife in the drawer, but the way that it's written, it's hard for me as a licensed attorney who's been doing this for well over a decade. It's hard for me to determine if this is on the ballot, and I'm assuming that they only have one yes and one no. If they only got one yes and one no, I don't know if I'm voting for the actual process to approve it or if I'm voting for the actual removal. It's kind of confusing. That's why I said you probably want them on separate ballots to make sure you don't have any confusion. But if you're going to put both referendums on the ballot, you should have referendum 1. This is the process. Do you vote to agree to this process that the village will adopt to remove its elected officials? Yes or no? And then once they select yes or no, then you put the second referendum up. The second one would be, do you vote to remove Tiffany Henyard in accordance with the process noted above, or in accordance with the aforementioned process? Do you vote to remove Tiffany Henyard? Yes or no? It would have to be 2 separate referendums with 2 separate, a yes or no for referendum 1 and a yes or no for referendum 2. I don't think they did that. Okay, on April 25th, 2022, Henyard filed a two-count complaint in the Circuit Court of Cook County. In count one, she sought a declaratory judgment that both referenda were invalid for numerous reasons. So let's see what reasons she cited as to why they were invalid. In count two, she sought a declaratory judgment declaring that the constitutionality of the referenda, because any recall of a specific official would have to wait until after the village board placed a recall mechanism on the ballot for voter approval, and that the two referenda cannot coexist on a single ballot. I already think that's a good argument in and of itself. And hell, we on page 4. We ain't even gonna make it to page 23, but we on page 4, and I'm like, that could be a valid argument. So again, she's saying that. I want to read that again because I thought that was interesting. She said she's challenging the constitutionality of the referendum because any recall of a specific official, so they're talking about the recall of the mayor, would have to wait until after the village board placed the recall mechanism on the ballot for voters to approve, and that the two referendums cannot coexist on a single ballot. I think that's just a common sense argument, even if you didn't have a detailed nuance. If they have to vote on the process, then once they vote on the process, and the process is, her argument is they have to vote on referenda one, the process which they're going to recall me. Then once they vote on that process, now that that is done and in the books, they have to vote separately saying that they're going to recall me. They can't do both in the same ballot provision. That's the argument. In particular, she argued that the language of the first referendum, the confusing one that was too long, specifically limited the ability of the voters to recall an official at some point after the certification of the results of the June 2022 general primary election. She contended that the second referendum, specifically recalling Henyard, was invalid because it was presented simultaneously with the first, and therefore and therefore conducted before the certification of that election. Hey, we just talking about from a common sense standpoint. Y'all let me know what y'all think. I know some people going to say, man, this dude Tiffany Henyard friendly, but hey, I low key think that that's a viable argument. Let me see. Let me look at some of the comments real quick. That makes me happy to hear you as well. Let's see. They passed both referendum of recall and voted or recall in the same action. That's actually stupid. They needed to pass the referendum first, as is, let it pass, and enact the law to process it, the recall referendum. 100% accurate, Counselor A. Co-counsel, shout out to you. You are all in it. This is something that, I don't know, I'm going to just be honest. I think it's like patently obvious. Now, we'll address the malpractice because I know you said, like, yo, how is that not malpractice? But if I read to you the threshold amount for malpractice, you can have a really shitty attorney, and it's technically not malpractice because the attorney could actually be trying his hardest. He just sucks ass, and courts have found that that's not malpractice. Just because your attorney sucks, it doesn't mean that he wasn't trying his best and using and representing his client zealously. It's a crazy standard. They try putting everything in one box in the same action without allowing the time to enact the past referendum. What's good? Shout out to my guy Wolverine. Hey, you late to the party, man, but better late than never. We doing a legal dive into but this goes to my point, how terrible the trustees generally are. And I'm not talking about terrible. I don't know. There's a lot of terrible stuff going on in general, but this goes to my points because remember, I think we were looking at the last live on Wednesday. We were looking at the Thornton Township board meeting, and they put a proposal in to adopt the Roberts Rules of Procedures that municipalities use. And Gonzalez was being a jerk. He was like, "We already use them. Why we got to pass them? That's why you have to pass it and adopt them formally because you're using them." But the first thing I said is they need to adopt some rules because whatever the fuck it is that they're doing now, it just isn't working. I don't know if they aren't reading it. I don't know if the attorneys are just doing a shit job or if they don't care. But all of the all of the things that they wanted to get done, they could have actually done had they went through things with a fine tooth comb. They could have actually avoided all of this shit. It's actually kind of crazy. Yeah. All right, so let me go ahead and jump back into this real quick. But we get the gist of why it failed. But this is just what Henyard's lawyers are arguing. And shout out to her attorneys. Great argument, I think. I mean, just from a common sense standpoint, from what we saw in 2016, we already got a little guidance. But I'm going to scroll down because I want to get to some language where the court looks at a previous case. And that case kind of outlines how the referendum has to be structured, how the language has to be written so that it's clear and not unambiguous and fucking confusing. You got to write stuff in plain English. And I know I have a problem with that. When I write something that's going to a non-attorney, I have to write it like 3 times because the first time is going to sound like I'm writing it to a judge. The second time is probably going to sound like I'm writing it to opposition. Then the third time, the third time is when I kind of trunk everything down to some common sense language that doesn't require someone to pull out a damn Google or do a law dictionary or something like that. So let's go ahead and jump back into this. Let me go ahead and get the screen set up just in case y'all wanna read along. Okay. All right. So Henyard sought an order requiring the village clerk not to certify the referendum to the Cook County clerk, and if the village clerk had already done so, to direct the clerk to decertify the referenda and not place them on the ballot. Henyard then moved for injunctive relief. We talked about this. She wanted them to stop and excuse me. She then moved for injunctive relief and an expedited schedule. Attached to her verified motion were copies of 2 village board resolutions placing the referenda on the general primary ballot. On excuse me, what the hell wrong with me? I'm struggling. 2 board referendums placing the referenda on the general primary election ballot. On May 17, 2022, without notice to the defendant, the circuit court granted a temporary restraining order prohibiting the village clerk from certifying the referenda in question pertaining to the questions on the ballot. The order recited that Henyard would likely suffer irreparable injury if a temporary restraining order were not granted. No matter how much you think Tiffany Henyard sucks, if a terrible recall that didn't follow the rules were allowed to go forward and she actually was out of her office because of something that wasn't done in accordance with the law, that would actually be terrible. I don't care how terrible the person is, you got to follow the processes. All right. On May 19th, the trustees filed a verified motion in opposition to Henyard's motion, arguing that release was barred by latches, and that's what we talked about. The trustees said, yo, she can't make those arguments because she didn't bring them up in a timely manner and because it was an improper attempt to interfere with the legislative process. Wah, 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 wah. Crimea River. The trustees indicated that Henyard had not vetoed the resolutions within a normal time frame from doing so, and that she had waited several months before suing to overturn the referenda. They also argued that the matter was not yet ripe for adjudication because the referenda had not yet been approved. On the same day, the trial court stayed temporary restraining order and set a schedule for further briefing. Blah, blah, blah. The circuit court's oral arguments, blah, blah, blah. The court further indicated. All right, we're going to skip through all of that. Let's see if we can get to the analysis. We're going to get into the analysis. Long story short, everybody's suing everybody. The Henyard is arguing the right position that, yo, this was whack because y'all put everything on one ballot when y'all shouldn't have. It has to be one thing done. Then after that's approved, then you move to the other step. The trustees are saying like, yo, this should be barred by latches because she had an opportunity to raise this. She waited 2 or 3 months before she filed litigation. She's just trying to interfere with the legislative process, and she didn't even exercise her power to veto it. So those are the arguments. The court is like, yo, this is actually a pretty important issue. Nobody's going to get recalled or get kicked out of their seat until we figure out what's going on. So we're going to put a stay in place. We're going to put a temporary restraining order stopping all of this shit from happening until we figure out what we need to do. All right, so these are the breakdown. These are the one, two, three things that the trustees argued. One, we talked about Henyard's defenses are barred because she didn't bring them in a reasonable amount of time. The first referendum, two, the first referendum was a valid exercise of the village home rule powers under Section 6F. This is what they're trying to, this is what they learned from the first one. We need to have referendum one before we can move to referendum two. They just tried to lump all that shit together. It's like I don't know about y'all, but I'm a grown ass man, but I love a good peanut butter and jelly sandwich. Like, yo, you get the nice potato bread, no edges, cut it diagonally. Ooh, fire. Now, what I don't like is, and trust me, I tried it once because it looked cool. Going in the store and getting the peanut butter jelly that's already mixed. That shit look good when it's in the jar, but when you actually try to use it, it's a shitty mess. And literally, this is the peanut butter jelly in the combined jar situation. It looks good on the outside, but when you really try to use it, it's just messy. You don't taste anything. It's too much jelly here, not enough peanut butter over here. Shit stuck to the roof of your mouth. You need a thick ass glass of milk. It's shit just real ridiculous. So there's a lot of combined peanut butter jelly action going on. I don't know if that analogy made sense, but damn it, it made sense to me. All right. And the last thing that they argued is that the second referendum was properly considered by the voters. All right. First, they addressed jurisdiction. We're not going to go into jurisdiction because they have jurisdiction. Blah, blah, blah. We're going to skip all that. Injunction. Let's see. I'm trying to find. I want to find the quote. Give me 1 second because this is a little long. I got to go through it. We gave concern about. Oh, you consider a temporary restraining order. Nothing in the record showed the party specifically stipulated converting the brief into. This is all background stuff. All background. Judgment on the pleadings. They're talking about judgment on the pleadings, declaratory judgments, motion for summary judgments. Real short, because when I start reading, they may have some of that language in there. Declaratory judgment, judgment on the pleadings, motion for summary judgment. What that means in short is, let's say I'm suing you. I'm the plaintiff and you're the defendant. And I file my complaint. I'm like, oh man, you did all this goofy shit, and now I'm suing you. And I filed my complaint, and then you read the complaint, then you got 30 days and you file your answer. Like, no, I didn't do this goofy shit because of this, this, and this. Then you found your answer, and the court has my complaint and my answer. Essentially, judgment on the pleadings, the things you submit to the court are the pleadings. Judgment on the pleadings means we don't need to hear any testimony. We're going to just look at what you said happened, and we're going to look at what you said happened in your answer, and we're going to make a judgment. They're asking the court to judge based on what the parties drafted and gave to the court. That's a judgment on the pleadings. A motion for summary judgment, and they're all the same thing. They're just asking the court to make a decision on the case without going through the witnesses and submitting documents and the evidence. A motion for summary judgment is if each party, if me and you, I'm suing you, you cross suing me, if both of us agree to the facts of the case, there's no need to put on any evidence. If there's no, the language is, if there's no genuine material issue of fact, that means that we don't dispute the facts. What I wrote down, you say are the facts, and which you look at it and say, yeah, those are the facts. If we don't disagree on the facts, they're asking, hey, because the facts on that issue, you can make a ruling as a matter of law because we don't need to submit evidence because we both agree that what we have on paper is what happened. So that's what you got when you got a judgment on the pleadings, a motion for summary judgment, declaratory judgment. They're just asking the court to make a decision without going through bringing people to the stands and submitting documents and all of that shit. All right. It says we're gonna start here. We first addressed the trustees' contention that Henyard's claim is barred by latches. They didn't. They're essentially saying, "Yo, you didn't bring this in time." Although the trustees did not plead it at the circuit court, latches is an affirmative defense. The trustees contend that Henyard waited. Now, this is actually interesting. Let me read that again. We first addressed the trustees' contention that Henyard's claim is barred by latches. yo, you didn't bring this in time. Because you didn't bring it in time, you shouldn't be able to assert it. Although the trustees did not plead it as such in circuit court. They went at the trial court and they did not make this argument at the trial court level. Now on appeal, they're making an argument. That generally is a no-no. If you don't bring it up in trial, you can't make a new argument at appeal. That's not the appeal court's job. The arguments that the appellate court is looking at is the record, what happened at the trial court. So it's actually funny because they're saying that Tiffany Henyard defense should be barred because she didn't bring it in time. If I was Tiffany Henyard, I would say, well, shit, the shit you saying right here should be barred because you didn't bring it up at all until now. Bad lawyering, probably not malpractice, but definitely a terrible understanding of how appeals work and what the doctrine of latches actually means. Trustees contend that Henyard waited 4 months to sue after the resolutions were adopted, which they assert were too long. Whether latches bars a claim depends on the facts and circumstances of each case. A valid latches defense requires, amongst other things, a finding that the opposing party was prejudiced by the plaintiff's delay in bringing her claim. Additionally, latches is almost impossible to successfully assert against a public entity such as a mayor or county clerk. Now look at this bad lawyering. They're arguing a defense. They're saying that Tiffany Henyard didn't bring these claims in time under the doctrine of latches, so therefore she shouldn't be allowed to bring them. But it says here, additionally, latches is almost impossible to successfully assert against a public entity such as a mayor or county clerk. Why? As our Supreme Court has explained, they actually cite a case, Hickey versus Illinois, where the Supreme Court had essentially said and it's very, very rare and hard to use that doctrine against a public official. Now, again, the other stuff, maybe not malpractice, but this actually might be malpractice, or is a good argument for malpractice because you essentially made an argument which is wrong, and there's a Supreme Court case in your state that tells you why is this wrong. Did you not hit the research button or even use fucking Google? So again, that could be a fair grounds for malpractice, but let's just think about this common sensely. Like, if the trustees sued their attorney for malpractice for being a bad lawyer and they got some money back to go back to the people in the town, in the village of Dalton, when that insurance premium goes up, the village is paying for it. It's a circular thing. Like, oh man, my attorney was terrible. I'm suing him for malpractice. Well, you are the village attorney. Like, I don't know. It's it, it the trustees have this attorney representing the village. They're paying this money into it. It's just it's a circular argument that wouldn't even be fiscally worth it if they sued for malpractice. Yeah, they might get something back from the malpractice insurance, but would they really? And before we jump out of here, we'll look at the malpractice standard. It's a very hard standard to prove. So they said that, yo, trustees, y'all didn't do y'all research. Y'all can't bring that. Now, that brings us to the merits of the attack of the two referenda. The village of Dalton is a home rule government. We talked about this before. Our Supreme Court has explained whether home rule or non-home rule, they all are a creature of the Constitution. And it says, we talked about this before, a home rule shall have the power to approve a referendum to adopt or repeal any form of government provided by law, blah, blah, blah. The trustees devote a good part of their brief to the facially appealing argument that the referenda must be upheld simply because the voters are sovereign and upholding a referenda would vindicate the manifest will of the voters in Dalton. So the trustees are saying, like, yo, we didn't do it right because we kind of suck. Our attorneys probably told us wrong. But even though we didn't do it right, you can't usurp the will of the people. The people voted to get her up out of here, even though the shit was confusing. So if you rule any other way, you're taking away the voice of the people. which is a terrible argument. In this argument, they rely on a statement made by our Supreme Court in this court uh, that extol the value of ballot access and the need to recognize the rights of the voters to select candidates of their choice to lead their communities. These values are paramount and important, and nothing in this opinion is intended to take these rights of the voters away. However, simply reciting these values do not resolve the unique and unprecedented question before us. It also fails to recognize the sovereign authority to alter the form of local government is jointly held by both the voters and the General Assembly. So they just made an argument to the court that wasn't based on law. It was just based on, they call it dicta, where if I'm a judge and I'm writing an opinion, and somewhere in that opinion I say, hey, because the will of the people have to get recognized, and then you file a case and you say, hey, Your Honor, you have to do what we want because Judge DFD said in a previous case that the will of the people has to be recognized. That shit ain't that don't mean anything. It's just dicta. It's just me talking. It's not the court actually laying out law. So they tried to make an argument to the Court of Appeals that wasn't even based in law. It was just based on one or two lines that was in a court case, and they pulled that out to take it as if it was binding precedent. Hey, I don't know. You might be onto something. The more I read this, I'm like, damn, these lawyers suck. Is this malpractice? It's starting to smell malpracticey, but I don't know. Let's take a look at it a little bit more. Okay. Let's see. All right, it says, however, simply reciting, blah, blah, blah. It says power to govern the sovereign authority is held both with the voters and the General Assembly. Even after voters approve a referendum to change a form of government, the General Assembly may reverse the action even to the extent of making the change retroactive. And they had a court case where that happened before. And they go into other cases, leading scholars. We are not going into the leading scholars of the 1970 Constitution. Ooh, that's rough. But the guiding case is a case called leak. Leak. The holding in leak is clear. A referendum submitted under the provisions of the Constitution must be able to stand on its own terms. Excuse me. If the referendum submitted to voters is not self-executing, leaving gaps to be filled by either the legislator or the municipal body, then just what was approved by the voters is uncertain. More recently, the court invalidated a referendum to allow municipal voters to enact the city ordinance by initiative and referendum, holding that moving legislative power from the city council to the voters in a manner that would not change its form of government is unconstitutional. So the big takeaway from this, because I don't want to go too deep. Let me see the Williams. Do we need that? Let's see. When a court. Okay, this is actually interesting. Real quick, I want to touch on this because in this case in 2022, they even cited back to the 2016 case that we addressed earlier, where Henyard was a trustee. And it says when this court considered Henyard herself was not a mayor but a village trustee. She had voted against the ordinance. This is the earlier case we talked about, and she was the lead plaintiff in the case. Amongst other things, she argued that a specific case Williams governed and that the ordinance was invalid because a recall of a municipal official was not a change in the form of government under Section 6F. So she clearly learned something from that original case in 2016. Let's see if there's anything that's simple that I can pull out that's pertinent. Hey, the first, blah, blah, blah. Okay, and here's where the court essentially scolded the trustees. This is a good paragraph to read. We find the argument dispositive. The trustees were clearly determined to use their authority to remove Henyard from office immediately, regardless of the fact that Illinois law does not provide for a recall of village officials and the fact that the village had not previously adopted a recall mechanism by referendum. The verbal gymnastics necessary to draft two referenda in a way that would allow Henyard to be removed midterm resulted in an erroneously convoluted, confusing, and ambiguous question, which clearly violates the clarity and precision requirements that our Supreme Court has set forth in two cases, Leck and Lipinski. In particular, the phrase, and they broke down the language, in particular, the phrase, and to immediately create a vacancy in the office of village president mayor to be filled in a manner provided by law for filling such vacancy by a majority vote of those voting on a question whether to recall and remove it. I don't even, and the more I read it, the more my head hurts. Can easily be read in two different ways. So the court is saying the way y'all wrote this shit, it can be read in two different ways. Under Illinois law, a midterm vacancy in the office of mayor is not immediately filled by the voters, but is filled by the village board electing blah, blah, blah. Now, I'm not about to go up there. I'm not about to go into all that. It says, we find that the referendum is fatally vague and ambiguous under the doctrines enunciated by our Supreme Court. The holding makes it unnecessary for us to address Williams' court determination because recall is not a change in the manner of selection of municipal officers as provided therein. Voters can never establish a recall mechanism by referenda under Article 7 under the Constitution. Our disposition of the claims regarding the first referenda invalidates the second referenda. Nonetheless, since this is a case of first impression, involves the public interest, and is likely to be reviewed on further appeal, we address and resolve whether the separate agreement that Henyard makes against this. No. We stopping that right there. I'm about to X this shit out. I'm about to X that out. No, that was going too deep, and it's a little too late in the game for me to go through all that. But let me go ahead and hit some of this comments up. I'm gonna give a quick recap after I jump up on some of these comments. I want to make sure I can catch everything. Let me see. I mean, they need to adopt something because they don't know what the fuck they doing. Pardon my language. I don't know if it's because I don't know. I don't know if it's because it's a small town municipality. I don't know. It's because like municipality law is a very nuanced area of the law. Like if you got a municipality question, don't fucking ask me because I don't know. It's clearly convoluted. It's a lot of case law that Supreme Courts in various states has done. Like it's just a lot. So I think they're just hiring any attorney who says like, "Yo, we can do this." Excuse me, on behalf of the village. And I don't know, they may be hiring like criminal defense attorneys or ambulance lawyers or something. I don't know. I should. Damn, did I already X that out? I already X'd it out. I was gonna look through the pleadings to see actually who the attorney was in that case. Kenya says often that the trustees are just to vote on things. No, the trustees are the checks and balances to supervise the supervisor or the mayor, and it helps them full stop a person if they're out of order. Yeah, it keeps them from. Shout out to you. I knew it. Malpractice. The standard for malpractice is crazy though. Like I remember my very first trial. I was actually scared that I had committed malpractice. I don't know. I told this story, but I don't think I told the malpractice part. I had like my second day on the job. My second day as an actual licensed attorney in court. I had two trials, and I won the first one, and I lost the second one. And early on, my client's sitting next to me. I'm sitting there. The prosecution has their witness on the stand, and they're talking. And I'm listening because, like, this is like my first day, and I know all of the rules of. I don't know all the. I know the rules of evidence, but I'm so shook. I had like a laminated cheat sheet of like just things that I might need right in front of me, and I had like a little cheat sheet with the breakdowns of the rules, just in case I got to object. Objection, Your Honor. Objection, Your Honor. Relevance. Objection, Your Honor. And, I needed to know these things right there in front of me. This is my second day on the job. I ain't want to fuck nothing up. So I'm listening to make sure he doesn't say anything or question isn't asked that I need to object to and argue over. And as I'm listening, my client starts talking to me about something or other. And as he talking to me, I'm explaining something to him, or we talking about something, and then I don't hear the question because this dude's talking to me, but I hear the answer. And by the time he said the answer, I was like, wait, I was like, what? I heard the answer. I was like, oh shit, I think I missed an objection. And I was like, I was like, I think I missed that objection. So I lose that case. This is criminal shit. So it's like people freedom on the line. And so I was like stressed out. I was like, oh man, I missed this objection. This guy gonna hit me up for malpractice. Cause I don't know. I don't know if it was. I'm not even sure what the question was because no cap. I didn't even hear the question because this dude was talking to me. I just heard an answer, and the answer sounded like some shit I should probably object to. But by the time that thought came in, by the time I heard it, it was already said. And you know, they always say when it comes to witnesses, you can't unring a bell. Like if you say something and I stand up and be like, "Yo, I object on the grounds of this," and the judge agree with me, he like, "Hey, jury, strike what you just heard. You didn't hear what you just heard because y'all can't take that into consideration." They're gonna be like, "You don't want me to take into consideration what I just heard because you're telling me that I didn't hear it?" Okay. So, I don't know. So I thought I committed malpractice. So, but the standard for malpractice is a very high threshold. Yeah. Fair point. Fair point. Oh, no, no worries, no worries. I appreciate y'all for tuning in, and hopefully it wasn't too convoluted. Y'all sharp though. Y'all intellectual savages, so y'all could track everything. Sounds like a lot of lawyers cashing in on all the shenanigans and then walking away. Facts, yo. Shout out to you. That's a outstanding comment. You get a time. All of this shit is costing the taxpayer money. The taxpayers are the one when the mayor sues the trustees, the village is paying for the attorneys on both sides. The village is paying for the attorneys on both sides. But hey, to be fair, Tiffany Henyard, I know uh, when I initially was talking about the recall, because I just talked about it was like, oh, it was some procedural thing that wasn't followed, and I didn't dive into the case. Man, I got so much stuff in the conversation with like the judge was working with the law firm. And people like the judge was working with the law firm, or Tiffany Henyard is cool with the governor, and the governor influenced the trial. And I was like, I don't know if that's it, bro. I was like, well, if you say so, but I don't know if that's it. But now that we had a chance to look at it, like, yo, her position was a correct one. Her position, her legal argument was right. Shout out to you for tuning in. Let's see. I wanna see it's the same lawyer. Okay, okay. Hey, I appreciate it. I'm gonna pull up real quick. Yeah. When you hope all 12 jury members have serious short-term memory issues, they're right, they are remembering. Yeah. And sometimes this is crazy. Like this is wild. Like the reason I the prosecution witness is on the stand. Let me lay this scenario again, just in case somebody joined the prosecution witness is on the stand. I'm on my second day as an attorney in court, and I'm at a trial, my second trial of the day. I got a victory the first one, and that was only God. So my second trial, and my client starts talking to me. I turn to engage with him. I don't hear what's being asked, but I just hear a response. And by the time he says a response, it's already out. Everybody heard it. And I was like, oh man, I think I should have objected to that. Now I have two things I can do. And I think this is the smarter thing. It wasn't malpractice, but this is just strategical. I had two things I could do. I missed the question. I heard the answer, and it sounded like something I should have objected to. But after he said that question, they moved on to the next question. I could either I could stand up and, Your Honor, I object based on X, Y, and Z. And now we having this big argument with prosecution over the objection. And now everybody who just heard that question is analyzing that question. They're analyzing what he's saying. Whatever he just said that I think I missed as an objection, once I stand up and object after he already said it, now every juror is zooming in on what he just said. So your options are: do I object and he already rung the bell. If I object, it's like me going up there ringing the bell 20 more times. Ding, 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 ding. Y'all hear that shit? Or I just sit there and say, let them ask the next question, and hopefully the bell was rung once. It's better to ring the bell once, and hopefully the jury kind of forgets about that bell ring as opposed to me challenge it and we ring that same bell in that same tone 30 times and just sear it in the brain of the jury. So I had to make a decision. So at that point, I was like, you know what? I'm gonna just be quiet on this one and let it go. The village is being built. My attorneys are both sides, but they can't afford copy paper now. Facts. They can't afford. Hey, to be fair, ink toner is expensive. But yeah, that's sad. They broke. When you can't afford, hey, shout out to you. That's a good comment. When you can't afford toner and ink in your municipality, that's a overall that's an overall bad look. Hey, shout out to you. I appreciate it. Let's give a round of applause for becoming savage community where we try to have a little fun but talk about things that are legit and provides a real perspective. Now, real quick, because hey, my guy Royster, you've been going in on malpractice. Let's go ahead and take a quick look at the language for malpractice. I'm gonna pull it up. I'm gonna look in the beautiful state since we talking about it. Let's see. This is going to be interesting. I don't want to bump this microphone because if I bump it, let me turn this computer. If I bump it, it's going to throw everything off. And y'all know I can't multitask. I can only do like two things at one time. So let's see. Uh, hmm. No, I don't want that. Not that. Give me 1 second. I don't want that definition. I want. I'm trying to. I gotta go in there. Hold on. Let's see. I know I need to look. The rules of professional conduct. Illinois rules of professional conduct. Let's see. All right, I got a general definition here. It says, all right, now you got an argument, but I'm gonna show you where it essentially, okay, I'm gonna read the definition. In Illinois, attorney malpractice occurs when a lawyer's actions or inactions cause harm to a client by failing to meet the standard of care expected of a reasonable attorney. Remember that down. A reasonable attorney. It don't say of a high speed attorney. It says of a reasonable attorney. One is negligence, failing to exercise the care, skill, and diligence expected of a competent lawyer. Examples include missing deadlines, inadequate research. Hey, you on to something? Inadequate research and failing to communicate important information. Breach of fiduciary duty, failing to act in the client's best interest, or conflict of interest, putting personal interest before the client's. Other examples of attorney malpractice include providing. It's just so difficult, man. If I'm gonna have to find a case law, I'm gonna have to do a video on what is malpractice because when you hear this, you're 100% right. But courts are reluctant because what is malpractice for one attorney might not be malpractice for another attorney. And I know that sounds wild to say, but you can't hold every attorney to the same standard. And I know you think like, well, what if we didn't hold every doctor to the same standard? Hey, It's different professions, bruh. That's just what it is. It said other examples of attorney malpractice include what we just read: providing incorrect legal advice, failing to obtain client consent for a specific action, mishandling client funds, yeah, engaging in unfair dealing, and failing to follow reasonable client instructions. To provide mal to excuse me, to prove legal malpractice, a client must establish these things. One, that attorney-client relationship existed. Two, that the attorney breached the duty of care. Three, that the breach caused the client's injury. And four, the client suffered a financial injury. In Illinois, the statute of limitations for filing a legal malpractice lawsuit is 2 years from the client knew or should have known of the injury. That's hey, let's give a big shout out to lawyers writing laws. Let's give a round of applause and a shout out to lawyers writing laws to help lawyers. Most places, if you engage in something, the time that you could be sued is 5 years, 7 years, but they're like, hey, for attorney malpractice, you got 2 years from the date that you knew about it or you should have known about it. So, hey, shout out to lawyers making rules for lawyers so they can have a little bit more, a little less culpability when they fuck up. That's kind of terrible, but it is what it is. Yeah, it is what it is. Yeah, that's funny. The client would need to prove that they were not advised against an action, but proceeded anyways. We have no idea what the lawyer said. I don't recommend this. I agree. It's just the other thing too is all attorneys under this standard, all attorneys can't be evaluated for malpractice equally. Let's say, like, yo, something happened and you needed to hire an attorney, and you came to me and was like, yo, DFD, wow, and this dude charges $750 an hour. But you found another attorney who charged $250 an hour. And hey, I've been doing this 15 years. That other guy, I've been doing it for 3 years. All right. So it's plausible that his level of research may not be as precise as mine. At that, if somebody doing it 3 years, just to keep it a buck, he might not have the resources. These attorneys, they might not even have. Some attorneys don't even got fucking paralegals. They in there doing their own research on their own. They're calling all of their clients and disguising their voice to sound like their secretary. They're using AI to describe their voice to sound like a British woman. So they think that the British woman work at the front desk, but they really have an office set up at their home. So malpractice of an attorney, it has to be like super egregious. Like you didn't even absolutely try. And how are you going to evaluate that evidence? Like, hey, I did my due diligence. I went on, I started my research with a Google search, then I went and pivoted towards using Lexis. Then I used Westlaw. I used both mediums to actually do a search. Then once I found this first case, I shepherdized that case to make sure that case was still good law. Once I confirmed that that case was still good law, I mean, there has to be some room for skill set, for competency level. It's just a difficult thing to prove. So, hey, it is what it is. I agree with you, but well, well, the statute of limitations hit right. Hey, if your lawyer fuck up, you got 24 months. You got 20. This is crazy. You got 24 months from the time you knew about it or when you should have known about it. Because if I'm the attorney, I'm like, hey, bro, you should have known about this when I stood up there making that dumbass argument. So you say the statute of limitations started on this date because this is when you found out about it. I'm saying the statute of limitations started a year ago when you should have known that I didn't know what I was doing. So it's your fault. But it's just difficult to prove. I mean, that's hilarious. That is absolutely hilarious. But yeah, that's it for this video. That's just what it is. So it wasn't any finesse that was done by Henyard. She didn't use her ties to Joe Biden or the governor of Illinois. So she didn't use any leverage to get the recall overturned. It was just some bad writing, some bad lawyering, some terrible legal arguments. They didn't do their due diligence and research, and rightfully so. she was able to get a W. The worst part of this, though, the absolute worst part of this whole thing is that the worst part of this whole thing is that they could have actually fucking won this case and upheld everything had they done it right. And because of the incompetency on all parts, the people paying the taxes for all of these legal arguments are just suffering. This city is just going to be strapped and bankrupt, and it's going to take them 4 years to get in this mess. It's probably going to take them 12 years, 10 at least, to actually dig out of this mess. They're going to have raised taxes, the cost to do business of licensing, and all of that shit is going to go up. So it's terrible that they. It would be interesting to see what position the village would be in had they actually done this right, had they actually done things correct. But hey, maybe on Earth 23 somewhere in a parallel universe, Tiffany Henyard was effectively ousted, and the village of Dalton has like a $6 million surplus. But here on Earth 1, shit not looking so good. Okay, it is what it is. Yo, that's crazy. I'm gonna hit up these last few comments, then we gonna jump out of here. Hey, I appreciate it. I appreciate it. Thank you for that. Shout out to you. I'm appreciative of that. And that made me feel good. That made me feel good. I appreciate that comment. Yeah. Was the public not involved with the recall? The only thing they were involved with on the recall was actually voting on both of the terribly written measures that were smashed together on the same ballot to be voted on. I seriously doubt. I'm just looking at how they interact. I wouldn't do it if I was a city councilman. I wouldn't have anything. I wouldn't address the public when it comes to writing the language of a recall or what the process is to be done. I mean, low key, if my city councilman was like, "Hey, we need your help in how we should write this recall. How do you all think it should be done?" My immediate reaction, like, "Hey, we need to recall your ass if you don't know what you asking me how we should do a recall. You know what? I don't know how we should do one, but we should do one on your ass." So I seriously doubt that would just be a bad look. I mean, it probably could have helped. Low key, it probably could have helped, but I seriously doubt it because it would be a bad look. Yo, that's it for this video. I appreciate everybody. Next week, I don't know. Next week is going to be Nah, it's all cool. Nah, it's all good. No worries about it. We get here when we get here. We hit the comments up when we hit the comments up. Next week, I have some work matters to tend to, so I'm gonna try to do a live Monday because Tuesday through Saturday I'm gonna be out of pocket. I just got some shit I gotta work on. But I'll probably try to circle back and do a live on Monday. But what I'm gonna do in the interim is I'm gonna put a lot of pre-recorded content out on things that are going on, some interesting topics related to. Interestingly enough, I don't know if y'all been looking, but the stock market been ripping. Trump won, and Wall Street was like, "Yay!" Like, I don't know if y'all looked at y'all portfolio between election night and today. Shit is crazy. But I got some interesting topics that I'm gonna do some pre-recorded content on Henyard. I'm gonna cover a few election things, a few finance things. It's gonna be some interesting videos to get everybody through. And as always, hey, if you're a channel member, you get early access to all the pre-recorded content. Channel members get access to pre-recorded content early for original pre-recorded content, like a long ass live stream like this that we've already seen and a lot of people have already watched. If I chop this up, I'm just gonna put this out because it's a breakdown of a live stream that was done. But when I sit down and I have to get my team to do editing, hey, the members get all of that stuff first. So hey, y'all get connected. As always, y'all take care, be blessed, and be safe. Have a good weekend. And yo, if you're a veteran out there, hey, because I'm gonna see y'all before Monday. But thanks for y'all service. As a vet, I'm getting all sorts of free shit. I'm going to McCormick and Smith to get my meal. Then I'm gonna go to like 4 different Subways and get lunch for the week. I'm gonna go to 4 different Subways and get lunch for the week. That's what I'm gonna do. Yeah, boy, hey, you gotta be fiscally conservative. Yeah. Oh, I appreciate that, Paul. Shout out to you. That is dope. Hey, I appreciate that. I don't think I ever had that happen before, but man, yeah, you about to make me tear up. I'm truly appreciative. And oh, real quick, before we go, I want y'all to see something that's actually funny. I want y'all to see something that I'm not gonna show y'all, But I want to tell y'all about it. Um, every day, as small as my channel is, some videos may jump off and get 20,000 views. Some will get 100. Some will get 500, 700. But very frequently, I would probably say maybe 10 to 15 times a week, I get offers on like, oh, you should do this sponsorship thing or do this or do that. And I'm not really a big sponsorship person because um, I think I had one sponsor the entire 3 years that I had this channel up, and it was something that, like, yeah, I'll use this, and this can actually help people. But I've had YouTubers that I watched, and once they start becoming sponsor whores, I don't want to become a sponsor whore. Is one, but one sponsor reached out to me and was like, "Yo, we checked out your content, and we help people create like courses that they can sell." And I just laughed because I said they clearly never watched my channel because one thing that I loathe is like courses. Like y'all already know. Like at one point, I had a budget, my Excel spreadsheet that I use for my budget and net worth, and I just put that shit as a link and give it out. So I really don't like trying to beat everybody to death selling them shit. That's just not really me. That's not really my thing. So, but it's crazy that people like you want me to pay you to develop a course so I can sell people when it's my job to talk and explain shit. What the hell am I? Man, get out of here. I don't know. I think it's kind of crazy. I'm not that kind of person. It's kind of wild, but yo, I don't know. I just don't like being a always asking for shit and trying to sell shit that's disingenuous. Like if you got a real product, yo, that's dope. That's a cool thing to do. But just for shits and giggles, I don't know, man. That shit make me feel like a scammer or Jay Morrison or some shit. I ain't doing that. Hey, shout out to you as well. No weapon formed against me for gifting the membership. Oh man, y'all doing too good. I appreciate that as well. I'm about to jump out here. Hey, y'all take care. Be blessed. Peace.